Good morning, everyone. Welcome back to law school. We appreciate that you got up early on a Saturday morning to join us for Reunion 2022. My name is Charles Cannon. I'm the law school's Senior Assistant Dean. And before we begin this session, a few quick housekeeping items for today. Lunch follows this session, which is available in the Alumni Lounge on the left of the patio. This session counts for 1.25 hours of CLE credit, and the session is being recorded and will be available in late October on the new Berkeley Law CLE website. Information on the website will be found in your printed program. If you've not already done so, after this session, please visit the table outside the room where there's a sign-in sheet for CLE credit. The executive director of our Consumer Law and Economic Justice Center was the scheduled moderator this morning, and he tested positive for COVID last night. So none of us can be surprised. Delightfully, Professor Jonathan Glater has agreed to step in and moderate the panel. Professor Glater holds a JD from Yale Law School, an MA in International Relations from Yale University, and a BA in Economics from Swarthmore College. And I invite him to introduce his fellow panelists.
Thank you. Can you all hear me? Yes, okay. Thank you so much, Charles. Ted gave me some instructions about how not to mess up this morning's panel discussion. And so I'm going to introduce my fellow panelists. I don't have to introduce myself. Thank you again, Charles. And then I will share with you some comments from Ted. To my left is Amanda Prasuhn, who joined the Financial Aid Office in 2018 after several years of practice as a public interest environmental attorney. She got her JD from an institution I shall not name to the south of us on the peninsula, and has a BS in biological sciences from the University of Missouri in her home state. And Sophia Wang is an attorney in the Consumer Justice Clinic. And before that, she was staff attorney at Bay Area Legal Aid, where she provided holistic legal services to formerly incarcerated women and veterans experiencing housing instability. Her practice area includes advising people who are coping with the kinds of debts we'll be talking about in a moment. I want to tell you a little bit about the Center for Consumer Law and Economic Justice. So please don't, this doesn't count as my time yet. There are several highlights from the past year for our center that I want to share with you. First, we organized not one, not two, not three, not four, but 5 conferences over the course of the year, including the Teaching Consumer Law Conference and the first ever Summit on Coerced Debt, which is debt incurred when an abusive partner or family member generates debt in the survivor's name through fraud or coercion. We have convinced the California Supreme Court to look to the text and legislative history of the original FTC holder rule. Ask me about that after class, if you'd like, to determine that consumers should be able to recover attorney fees in addition to damages from auto finance lenders. And we've launched new courses, including Consumer Law and Economic Justice Workshop, a Housing Litigation and Policy Seminar, and a Credit Reporting and Economic Justice class. 3 of 9 consumer law classes taught in the past year here at Berkeley Law. And I have to share with you our greatest victory, which Ted might not tell you about, and which I cannot claim any credit for. We had our first late night TV credit this past year with an episode of John Oliver's Last Week Tonight on the profoundly troubled property assessed clean energy program, informed by Ted. Future plans include expansion of what we call the Class Network, an organization of consumer law advocates, scholars, and students nationwide. Ted also gave me a short statement to share with you in which he says, "I'm so sorry not to be able to be here today. This session on the state of student loan law and policy shows Berkeley Law at its finest. It brings together an academic in the field, a clinical professor, and legal services practitioner, the law school's own internal sage from our financial aid office, and perhaps most importantly, a room full of alumni who are eager to learn, dedicated to solving societal problems, and restless with injustice." He's much more eloquent than I am. With that, now I can start my time. There are several places, when I was thinking about speaking with you all this morning, I thought there are several places I could begin this story. I could start with the rejection of George Washington's suggestion that there be a national university in the United States, or perhaps the Morrill Act in 1862, or failure to provide opportunities for returning servicemen after World War I. I could start with the GI Bill, which provided so many different forms of assistance to returning servicemen after World War II, and in particular, the innovation there of providing home loans to returning servicemen. Not one of these great steps forward came without costs. The Morrill Act provided land for great public universities, but whose land was it? The GI Bill provided what were then radical benefits to returning soldiers, but local VA offices did not make them equally available to soldiers, to Black soldiers who were returning from service. I could start with the National Defense Education Act, which actually in 1958 was passed in response to the launch of Sputnik. And the NDEA included a loan program for students to try to make sure that we identified promising young people would help us win the space race. Really, I mention all of these just to suggest that we have been struggling nearly since the founding of the nation with the question of how much, how best, and for whom to subsidize access to higher education. So I'll start with the Higher Education Act of 1965, which gives us the basic structure we have now for federal support of higher ed access. Student loans were not the centerpiece of the Higher Education Act, right? Student loans were a way of leveraging private sector resources because banks would make the loans and they would be guaranteed by the federal government. So it leveraged commercial money to provide funds to students. And one critical piece of this was the funding resource moved with the student. So the student could go to whatever college or university the student wanted to go to. But the centerpiece of the Higher Education Act was grants, right? Basic education opportunity grants. Problem was grant funding hasn't kept up with rising costs. And if you talk to students today, they will express their dissatisfaction with those rising higher education costs. States per student funding of public higher ed has declined in the Great Recession period and still has not in the aggregate fully recovered. And that's made federal aid that much more important. In the financial crisis, concern about those commercial lenders who are making those loans that were guaranteed to students available, credit dried up, right? Or access to capital dried up, which meant that those commercial lenders found it much more difficult to raise the money to make the loans to students. So one federal response to this potential problem was the broad expansion of what are called direct loans. And if you talk to students today who are just starting borrowing, that's the only world they know, right? They're borrowing directly from the Federal Department of Education because direct loans are the universe. This private guaranteed loan program has been shut down, although it's becoming relevant, and maybe we'll talk about this during the Q&A, in light of recent news and litigation over the president's cancellation plan. But I'm jumping ahead of myself. These loans, when made directly by the federal government, that's an asset on the government's books. So loans become viewed as a money maker for the federal government. Popular attention to student debt over time has increased greatly, really over the past 20 years, 15 to 20 years, in part because of the rising cost of tuition and in part because of the rising amounts that students are borrowing. The aggregate amounts of debt have increased steadily and then started to decline, interestingly, just a couple years ago. And there are many reasons for these patterns, but there's also much we don't know about the impacts of student debt. We do know a number of troubling facts. We know that there are racial disparities in the amounts that are borrowed. We know that there are racial disparities in the repayment rates and the default rates on student loans, which is not that surprising given disparities in wealth and given disparities in income and earnings in the labor market. We know that student debts seem to lead borrowers to put off major life investments like buying a home, like getting married, like having children. And we know, interestingly, that low balance borrowers who have balances in the $5,000 or less range, are actually more likely to struggle and to default on their obligations than the high balance borrowers, in part because many of the high balance borrowers are, for example, graduate and professional students who go on to careers that pay them more money, and so coping with the debt burden is more manageable. And finally, we know that the complexity of the system, about which I'll say more in a sec, also penalizes students. It's just difficult to navigate, and we'll hear more about this, I think, in a moment. The acronym, the sea of acronyms, right? The different repayment plans that students have to choose from, and the consequences of the choices that they make, right? There's income-driven repayment, income-based repayment. There's pay as you go, pay as you earn, right? Repay, which is the revised, I don't know what the the revised pay as you earn. So there are multiple plans that borrowers have to deal with. And of course, in the news lately, public service loan forgiveness, right, which was so badly administered for the first years of its existence that something like more than 95%, maybe more than 98%, if I remember right, of applicants for cancellation of indebtedness for working in the public sector, in public service, it's not exclusively the public sector, were denied. Okay, which brings me now to the actions by the Biden administration just in the past few weeks. The administration first adopted or implemented a waiver to make it easier for borrowers to take advantage of public service loan forgiveness. They simplified the process and made more types of loan repayment plans eligible for cancellation of indebtedness. They've also, this got less press, but it's quite significant. They've also made it easier for discharge of indebtedness for people with total and permanent disabilities, right? People who cannot earn what they need in order to cover their loan obligations. They've also made it easier for borrowers who are victims of various kinds of fraud, especially by for-profit colleges and universities, to mount what's called a defense to repayment, based on the deception that was deployed against them. And then most spectacularly, widespread cancellation of indebtedness. That's the $10,000 across the board, and $10,000 more for those student borrowers who received Pell Grants, meaning they were the most financially needy students in their undergraduate careers. The Congressional Budget Office just released an estimate this week, attaching a price tag to this cancellation plan of $400 billion. That figure got a lot of press coverage. What didn't get a lot of press coverage is a paragraph further down in the 4-page letter that describes what CBO did, in which CBO says, of course, we're making a lot of assumptions here. We don't know who's going to pick which of those several plans. We don't know who is going to be working in the public sector and therefore would have been eligible for cancellation anyway. So we don't have something to compare that $400 billion figure to. We don't have a way of valuing that cost against the benefit of eliminating balances for 20 million borrowers and reducing balances for 23 million more. We've got to step outside just the budget numbers, just the dollar amounts, to assess what is more important, what's more valuable. And still on the horizon, not getting a lot of attention because of these cost estimates and the broad-based cancellation proposal, are changes to the income-driven repayment plans. So these are the plans, that set of acronyms I mentioned. These are the plans that tie how much students have to repay to what their incomes are. And it's a fraction of discretionary income that student borrowers are supposed to repay. And the administration is proposing lowering that fraction and shortening the time period for which you have to make payments before you get cancellation. So if those policies are, and we don't have the details on them yet, if those policies are implemented, that could have a significant lasting effect for borrowers well beyond, right, the one-time cancellation. So I've tried to give you a little bit of a sense of the overview of the development of our student loan. I'm always hesitant to use the word crisis, but crisis has this sense of immediacy, and there's something about student loans that it's a slow boil crisis that just builds and builds and builds and builds. I've tried to give you a sense of the history and current events, and I'm going to turn next to Sophia to tell us about what you're seeing with real people in concrete terms dealing with what I've tried to sketch out in the abstract.
Thank you, Professor. As Professor Glater mentioned, I am part of the Consumer Justice Clinic at the East Bay Community Law Center, which is home to 8 of Berkeley Law's 14 teaching clinics. And at the Consumer Justice Clinic, we support and empower our clients in challenging financial institutions and to protect the money in their pockets, no matter how little. And part of that work involves working with student loan borrowers and helping them navigate this complex web of loans, repayment options, and available relief. And today I want to share with you some more of the story behind the numbers that you're hearing, behind the policy of student loan relief. As Professor Glater touched on, Biden's latest cancellation is the latest in a series of, I would say, piecemeal policies to provide relief to student loan borrowers, including total and permanent disability, the public service loan forgiveness waiver, and I especially want to highlight the borrower's defense to repayment. This didn't get as much press as I would have thought, but in June 2022, the administration announced an automatic group discharge for over 500,000 borrowers who attended the Corinthian colleges. And this has a huge impact on the Bay Area community, and it was something that my colleagues and I have worked on for years. And if you have been around for a while, you might have remembered seeing healed colleges, billboards, TV commercials, WyoTech, signs on the freeway saying, "Here's Healed College." Healed and WyoTech were part of the Corinthian College for-profit college franchise. And their business model relied heavily on false advertising to bring in students. And they earned their money through federal student loans. And it was a low risk for the schools because it was the students that took on the burden, all of the risk. And they intentionally targeted low-income, first-generation students, as well as veterans, because it was easy money, GI Bill, as Professor Glater mentioned. They promised guaranteed admissions into schools, job placements immediately after graduation, guaranteed that you can transfer the units that you took at Healed, for example, to a four-year institution to earn your bachelor's. And what our clients found was that these degrees were actually not respected in the fields that they were trying to get into. There were no job placements. Their units did not transfer. They would have to take out even more loans to get the units that they needed to transfer to a bachelor's program. And this bubble, the scheme that the Corinthian colleges are running, burst in 2015 when it closed, and my colleagues at the East Bay Community Law Center partnered with advocates from Housing and Economic Rights Advocates and Bay Area Legal Aid, which were other local organizations, and we banded together to mobilize and organize current students to get relief and former students. And at that time, the borrower's defense and repayment was in the books, but there was like a handful of people who ever used it. There wasn't even a formal application. I think it was like 5 people have tried to apply. But what it provided for was for borrowers to assert state law claims as a defense to repayment. And in California, this was good for us because we have very strong state consumer law protections against fraud and against unfair business practices. And so advocates, we were kind of improvising arguments, writing briefs, trying to argue that these loans should not be enforceable because their students were defrauded. And fast forward many years, the fairy tale ending is that now we're seeing automatic cancellation for hundreds and thousands of borrowers. And the longer story includes a lot of delays and lawsuits along the way, but it is incredibly rewarding to see how advocates turned something that was not really used into automatic cancellation and widespread relief for these students who were defrauded. And part of what I want to emphasize is the automatic nature of the relief, because the complexity of the student loan system cannot be overstated. Borrowers, typically, clients who come to us have no idea what kind of loans they have, which acronym it is. Is it a FEL loan? Who knows? They don't know what kind of relief they're eligible for, and all of us here in this room are not representative of most of the borrowers who don't keep up with student loan news. And the folks who are struggling to pay their loans are focused on making ends meet. They're not plugged in and simply don't have the time to find an application, apply for relief, and then follow up for the months and years to see it through, which is how long it has been taking the Department of Education to process almost any application for relief. And so while I do want to applaud and recognize Biden's most recent announcement about debt cancellation, the $10,000 and $20,000, I also want to point out that by requiring students to apply, borrowers to apply, it is a huge barrier to accessing relief. The biggest precursor, I think, to Biden's announcement has been the COVID-19 forbearance, which was another example of automatic universal relief to all federal student loan borrowers. And this was an unprecedented, almost 3 years, 34 months to be exact, of automatic forbearance for every single federal student loan borrower, which meant zero payments, $0 monthly payments, and zero interest across the board. And there were some significant exceptions for FEL loans and some student school-based Perkins loans, but generally it just had an incredible impact. And the fact that the department could make this happen, I think it's a very promising indicator of what kind of change is possible to truly reform the student loan system. And not only does automatic implementation make it easier for students to access, it also streamlines the processing and an administrative burden of the government. And I want to also share a little bit more about what that means. So one of the biggest benefits of the COVID-19 forbearance was that loan servicers stopped reporting negative credit information to credit reporting agencies. And so what that meant was that every student who was behind on their payments or in default was suddenly current. And this was instrumental in credit repair for many, many borrowers. And as we all know, our credit report history impacts every part of our lives, our ability to find rental housing, get jobs, access credit for basic necessities like purchasing a car, purchasing a home. And we know that the student loan debt has most impacted borrowers of color, communities of color, in particular Black borrowers. So this benefit of credit repair has been very impactful in giving opportunities to build financial stability, economic opportunities for these communities. A lot of the narrative on student loans has been focused on the numbers, like the amount of debt that's outstanding, the number of people who are in default, how much money is this going to cost taxpayers, but I would like to encourage everyone to think about the individual impact it has on borrowers, what the value is beyond the dollar, and think about the generational impact it has on borrowers' opportunity to build wealth. And ironically, in my eyes, it's not going to school and taking out the loans, but actually the debt relief that is fulfilling the original promise of higher education, of getting out of poverty and of upward mobility. And I would just encourage you all to think about that as you hear the news and listen to statistics.
All right, thanks, Sophia. I will say that my job here at Berkeley Law is to run our loan repayment assistance program. And so every day I'm working with students and graduates who are working in public interest jobs and utilizing these different programs that we've been talking about. So today I'm going to talk about how all of these issues and the student debt crisis is impacting law students and law graduates today, and talk a little bit about the mechanics of some of these programs. As Sophia and Jonathan have already covered, tuition costs have steadily risen, and so law school students are graduating with more debt than they've ever had. And with so much student loan debt, law school grads are typically facing two primary options. They can go into big law, have this really high-paying career where they can pay off their student loans aggressively and quickly and manage that on their own, or they can go into a lower-paying public interest job and receive the support of LRAP, a loan repayment assistance program, and public service loan forgiveness. Graduates in these lower-paying public interest jobs often have to enter into these income-driven repayment plans that Jonathan was talking about. What they do is reduce your monthly payment from something that could be thousands of dollars a month to something that's a lot more affordable for them. But these lower affordable payments have the impact of resulting in negative amortization or loan growth. Basically, by paying such a small payment amount, these payments aren't even covering the interest that's accruing on the student loans every month. So every year, every month, graduates are seeing their loan balances grow and they're ballooning. So when you have a loan balance that's growing over time, basically public interest graduates are kind of forced into doing public service loan forgiveness because they can't pay off their loans. Public service loan forgiveness allows for total loan forgiveness after 10 years of working in qualifying public service employment. But as we've talked about today already, the program is riddled with administrative problems, lots of ways to mess up, and borrowers can definitely feel constrained by some of the narrow employment qualifications. PSLF does require that you work full-time at a 501c3 nonprofit or in government, so it does sort of minimize career flexibility for these young attorneys. You would think that PSLF might be easy enough to navigate for lawyers and law graduates and faculty members who are managing complicated casework, but it's not the case. The program is so confusing that borrowers who have been out of school for over a decade are calling our office and wondering, what type of loan do I have? Am I eligible for these programs? How do I figure all of this out? It's really easy to mess up with these programs because people don't know that they've done something wrong until years have gone by. Thankfully, public service loan forgiveness has received this great but very temporary overhaul through this new public service loan forgiveness waiver. This was announced around this time last year, and it's a waiver that lasts only 30 more days. It ends October 31st of this year. But unfortunately, it hasn't made the program any easier to understand. It's actually made it worse. There's also some changes that are in the works. The Department of Education has issued some proposed rules that they hope to implement to make public service loan forgiveness more accessible. Let me talk a little bit about how public service loan forgiveness works right now. Basically, in exchange for having the right types of loans in the right type of repayment plan, making 120 payments on those loans, and doing this all while working in a qualifying public and service employment, you can get your entire loan balance forgiven tax-free if you apply through the Department of Education. It's going to require a lot of work for the borrower. They have to show the Department of Education that they qualify. They have to submit these employment certification forms on their own volition. They have to decide when to do it. The Department of Education doesn't tell them or remind them when to do it. It's like a PDF form that you have to do a wet signature on and then like fax it. So it's a totally outdated and hard system to navigate for people. And then borrowers not only have to make the payments and show proof of their employment, but they have to really stay on top of their accounts. Things go wrong all the time where loan servicers make errors, don't apply payments to your account correctly. So people who've had success with public service loan forgiveness are people who keep really thorough records, are willing to initiate an actual dispute with their loan servicer and even escalate issues to regulatory agencies. So if you think about this, doing PSLF and being successful with it requires a lot of privilege. You have to have the time, the resources, the knowledge, and even like the support of an LRAP program who can help you navigate this program. And obviously, law school graduates and lawyers are some of the best equipped borrowers to be able to tackle the public service loan forgiveness requirements because they do have that privilege and that education and that experience like in a courtroom, so they can get into these disputes with their servicers. And I will say their success rate has been high. Definitely here at Berkeley Law in the last couple of years, I talked to at least one person a month who's gotten their loans forgiven through PSLF. So it is a program that works, but you have to be committed to the program requirements, know what they are, and have the privilege of the time, the resources, and the support. Obviously, not everyone has had the same luck or the same resources. So if you've seen the news about PSLF, you know that a lot went wrong in the early years of the program. Borrowers weren't sure what they had to do to qualify. And I think Jonathan mentioned the first time the application opened, it was like a 99% rejection rate. So to remedy some of these issues, last year, as I mentioned, the Department of Education announced this temporary PSLF waiver. It says that through October 31st of this year, all periods of repayment on student loans can qualify for PSLF as long as someone was working in qualifying employment. And that means even for people who had the wrong type of loans or were in the wrong repayment plan or made late payments or no payments or missed payments, that can all qualify, which is great. What I've seen is the vast majority of borrowers who've gotten their loans forgiven through PSLF recently, it's been because of the PSLF waiver. I've seen it work in a couple of ways. Some people I've worked with definitely thought they did everything right for 10 years. And now that they went to apply for PSLF, they've seen actually something went wrong and they're benefiting from the PSLF waiver and able to get their loans forgiven. So that really shows us why the waiver should be extended. And actually, these waiver conditions should be made a permanent part of the PSLF program. Alternatively, I've worked with borrowers who definitely counted themselves out of PSLF completely. They knew that they had the wrong types of loans and they were committed to doing like 20 or 25 or even 30 years of repayment just to get rid of these loans and making these really small payments. And they're now eligible to get their loans forgiven through PSLF, which is great. So this PSLF waiver does take a big step to correct past errors and restore the promise of PSLF, especially for older borrowers who weren't counseled correctly. So if you out there think you could benefit or you have kids or family members who might benefit, definitely act immediately. Last thing I want to touch on is this new debt forgiveness plan, the 10 or 20K debt forgiveness. Basically, it depends on what your income was in 2020 or 2021 and whether you got a Pell Grant in college. You might think that this is incredible news. It is a great first step, but for people who have the amount of debt that law school students and graduates have, it doesn't make a huge impact, but it is a start. So for some borrowers, that relief is going to be automatic, but Sophia mentioned for most people, there's an application, which really puts the burden on the borrower and means that some people are going to miss out who don't know that they're going to be eligible. What we know so far is this application is supposed to open sometime soon, the next week or two, and it's going to close at the end of next year, which again is a disservice to borrowers who might not take action in time. But what I would say is stay tuned for more information as we continue to look at those updates from the Department of Ed.
So I have a list of questions because I'm endlessly curious in this subject. But I wanted to pause and see if there were questions in the audience first. And okay. There's a roving microphone.
You all use the word navigate, which is interesting to me because my question is, has there been any thought whatsoever given to the idea of applying the public trust doctrine to loan forgiveness? Because on the federal level, we had the FDIC, the Federal Deposit Insurance Corporation, and the Roosevelt White House, I guess, didn't want deposit insurance that much, but we did get deposit insurance, and we did get an FDIC, and there was such a thing as the Glass-Steagall Act, as that was coming up. But this thing sounds like an advertisement, from Trump University to help the clients make good afterwards. And, we have it already. There are public assets that not even the governor can just give away, and not even the legal profession can disguise them forever. And I was just wondering if, in this assertion of state defenses, if the public trust doctrine was something that anybody had thought about.
When you're talking about the state defenses, you're referring to the litigation that just was announced this week against the Biden cancellation proposal?
No.
No.
I don't know about that.
Oh. Okay. I'm gonna choose a particular way to answer that, and you're gonna please tell me if I'm not answering it in a or not responding in a satisfactory way, because what we were talking actually about before the panel actually started was wait a minute, where's the authority come from for cancellation? Right? What's the statutory basis for the department acting in this way? What's the doctrinal context in which we're operating? And there are two different answers. There are probably more, but the two that I've seen develop most fully. One is by the department's general counsel's office itself, which focuses on the HEROES Act, which was passed after the September 11th attacks, and includes language authorizing the secretary to take steps to alleviate the impact of an emergency, which broadly defined, by modifying loan terms, right? Modifying compromising loan terms. And so that statutory basis would look at this as a response to the impact of the pandemic, right? And that would authorize the secretary to act. The other one is going back to the Higher Education Act itself, which includes language also allowing the secretary to modify or compromise loan terms. That's the provision that the previous administration said no, doesn't allow the department to do this, because the language in the statute refers to person by person, individual, right, modification or compromise of loan terms, not a blanket modification, compromise, or cancellation of indebtedness. So we have dueling interpretations of the language in the Higher Education Act. So I don't know, right, that the corporate trust doctrine you're alluding to, whether that's been brought up yet in the litigation that's challenging the authority of the administration to do what it's doing. But those are the two statutory bases that I expect to be litigated as if these challenges proceed. I hope. Yeah.
No, the public trust doctrine does not have to be brought up. And
Please.
I was just, essentially, it's an affirmative obligation by the state. And that's why I'm curious about it.
By the state or by the federal government?
State. It's each state took title to beds of navigable waters and tidelands in trust. Yeah. And the doctrine has been expanded, well, in California, a lot, to be now a big discussion in water rights. But Massachusetts expanded the public trust to the public square. And, basically, the legal profession seems to have been engaged in a multi-decade effort to submerge any memory of the public trust doctrine. And, you know, essentially, it would imply reasonable limits on attorneys' fees. And I think that that might be the thing that, you know, the legal profession, I don't know a lot of stuff, so I was just asking.
Got it. I don't know, because I'm not sure how this ties us back to the student debt, right? The policies of the administration with respect to student indebtedness. Do you guys have, yeah.
Thanks for this really timely panel. So I would love to hear additional thoughts on the intersection of Supreme Court's recent rulings on the administrative state, and in particular the major questions doctrine, and some of the other anticipated challenges to the program, because I expect that they will be challenged. If it's not this case, it'll be another case. It'll continue to kind of go up. So I'd love to hear any thoughts. I know it's very early on how solid the footing seems to be from an admin law perspective, but also more generally as this gets appealed. I think everybody would probably be interested in that. But I think my question actually is a little bit separate. So I've done a lot of work kind of documenting the uptake gap with respect to second chances in criminal justice. And it strikes me as this kind of this statistic that was cited that 99% of those who were eligible didn't get, whether it was PLSF or some other. So I was wondering if that work is something you guys are still doing, because I think, and I actually advise a bit right now in the Biden administration, like the uptake gap, if you guys can document that and continue to sort of point out, well, we think this many people, even in the Berkeley community, is eligible, and this is how many seems to be able to access it, that would be a big service for those who are designing the programs and the implementation to actually get feedback. Because I think the issue with government in general is that we don't have the market signal back, right? We don't really know what is our addressable market and how many people are taking the product. But a lot of law only depends on it actually being delivered, right? And so I'm curious if that's on the agenda. I think that, EBCLC, and as an alum, I worked there while I was a student. It's such a powerful clinic and an organization center. So if that can be part of what you do, I think it can provide a real service to those who are trying to implement and make sure that the websites, everything is actually working, because they don't get that feedback as much as they should.
I'll say one thing about that is, in regards to this new debt cancellation plan, I know the Biden administration last week issued a state by state, this is how many people we think are going to be eligible. So I think they'll be able to compare something like that to how many people actually end up applying or getting automatic relief. I know here at Berkeley Law, I communicate with people at the California Department of Financial Protection and Innovation, and work with people who are in advocacy groups to let them know what's happening with our students and what sort of errors that they're seeing, so that they can communicate that to regulatory agencies and give feedback to people who are working at the Department of Education. I think there's probably a huge problem with simply not knowing how many people could be eligible for PSLF, because the Department of Education doesn't have this automatic way to look up where people are working and for how long, and that's been a huge problem. So I think there's a big gap in information there, and just not knowing how many people might be eligible for this program. Do you want to expand on that?
Yeah, the information gap, very real and very hard for advocates. And from the advocate perspective, you would think that the government actually has access to all of the data and information to run the numbers, figure out how many people, right? But we know that in practice, while the data may be there, we don't have the machines or the people to really understand or put it together. And we are still seeing people coming to students, borrowers who are coming to us who have never heard of COVID-19 forbearance and have been continuing to pay their loans throughout the pandemic, not knowing that they didn't have to. A couple weeks ago, we had a former HEALD student who came to our office for assistance. She heard offhand through the radio that there might be debt relief available, but until then had no clue that there were special closed school discharges and borrower's defense to repayment and a bunch of lawsuits specific to the school that she went to. And so it is very hard to get information out there. And from my perspective, I do think we should put the burden back on the government to synthesize this data. And I know, as Jonathan mentioned, there has been movement to make it easier for borrowers to benefit from programs such as the total and permanent disability discharge. Fairly recently, the Department of Education has been working with the Social Security Administration and with the Department of Veteran Affairs to share information about borrowers who have been rated disabled by the VA or are receiving disability benefits from Social Security, and matching that data to then forgive the loans. And I think we need more of that. And I understand there are a lot of concerns about privacy and sharing information, but the more work that can be done behind the scenes means that the people who need the relief the most can access it and will benefit, and it really reduces the burden on the individual borrower. I think Amanda also mentioned that, I don't know if it's before this or during the panel, about information sharing with the IRS as well. Part of the requirement for the public service loan forgiveness application is that you have to put in the employer identification number, the EIN of your employers. And as you all know, that is information that is on your W-2 and that is on your tax return and is in the government systems. And so you would think, I hope that we can get to the point where we can mix and match the data we need to get the relief to the students, and hopefully a speedy and smooth process.
One of the challenges we've confronted, just like at the University of California, is getting the word out, right? So we had a couple of webinars for literally thousands of UC employees who are eligible for public service loan forgiveness because they work for UC, we didn't break the servers, but there was a lot of people tuned in, and there were hundreds of questions, most of them highly particularized. Right? I took out this kind of loan 10 years ago. I have this kind of loan 5 years ago. Do I need to consolidate them in order to be eligible? Right? So there are all these very specific questions that come up. So there's both the broad awareness and then the specific advice people need in order to navigate it. It's part of why Amanda's role is so important, right, with working with alums. But that also means that, to your point about keeping track of uptake, it's a moving target, because the outreach is still ramping up, even though the October 31st deadline is looming. But the efforts to inform people have been increasing steadily for the past 4 or 5 months. It's going to be really interesting to see what happens as of October 31st, just how many people have gotten their materials in.
I want to take this from another angle. Has there been any consideration continuing to address this opportunity for bankruptcy discharge? Because I bet you if you could do that, all of these structures keeping up the records would automatically get a lot better. And I know that that's been something that's been talked about, and we have lots of banks and financial institutions that do not want that. But if we're talking about a vibrant economy, and we're talking about economic development, and we're talking about actually utilizing all the wonderful skills that these graduates and some of the people who didn't graduate, their contributions, that they could be great if they had the ability to discharge some of this debt. And if you did have that, I can imagine that all of the paperwork and the work to connect information about who's got what would be done, because there'd be interested parties who want to make sure, well, I want to argue that you can't discharge. Since you can't discharge, there's no incentive for so many of these groups to work to make particularized problem solving. If you could discharge it in bankruptcy, they would say, oh, I'm going to have to defend each one. So I'm just wondering whether we're still looking at that at all, because that's a major policy shift, and it's not always been that you couldn't discharge. If we've done it to make it so that you cannot discharge, can we certainly go to where you could discharge, and you would just have to prove I'm not eligible for discharge, as opposed to no one's eligible for discharge.
So it's true, education loans get exceptional treatment under the bankruptcy code, right? There's a requirement that a borrower show undue hardship, that's the magic phrase, in order to obtain discharge of indebtedness. But the problem is that phrase is not defined. So the result is both lack of predictability, potentially lack of consistency, and difficulty in obtaining the discharge, right? Which is your core point. And I
Don't have to have undue.
That's right. It's exceptional.
Educational borrowers have to
Yep.
make such a leap.
Right. And there are several law review articles trying to delve into the legislative history to figure out why it is that there was exceptional treatment of education debt. And for sure, in the 70s, when the first language was inserted in the bankruptcy code, there was rhetoric around borrowers who would take out their federal loans, graduate from medical school, file for bankruptcy, and then, laugh at the taxpayer. Not a lot of evidence has ever emerged of these conniving student borrowers, but regardless of the validity, the image is there. And so we have the language in the bankruptcy code. I think there's been an effort to introduce legislation to modify this standard several times in the intervening years. It just hasn't happened. It just hasn't happened.
I'll also say there are advocates who are working on that. Not our organization personally, but I have seen talks. It's a big thing that people are aware of and are trying to fix.
Could you,
It's also a shift in consciousness about what does this mean for people's lived experience and whether they can make it. And if they can find the conniving medical students, I'd like them to be presented.
could you say something about cancellation of indebtedness income, and does it apply to just certain programs, or is this another consequence that the student is going to have to bear?
I didn't hear.
Can you
repeat that? I'm sorry.
Yes, I'm asking about the income tax consequences of cancellation of indebtedness. And does it apply just to certain types of loans where that income tax consequence is waived as well? Or does it apply to any of these when loans are canceled under any of these programs or the pending programs or the pending legislation that you've been describing?
Sure, I'll take a stab at this. For public service loan forgiveness, the amount that is forgiven is always considered tax-free, so it is not reported as taxable income, so no income tax consequences. Then I believe it was last year, Congress introduced legislation, passed legislation to allow any type of student loan forgiveness to not be considered taxable income through 2025 in response to the COVID pandemic. So all of these different things that are happening right now where people are getting their debt forgiven is not having a tax consequence. So that includes this new 10 or 20K in student debt cancellation will not be federally taxable. The big thing we're seeing now, and this is why one person sued about this, is that states have the authority to decide whether or not to tax the amount forgiven. And it's a state-by-state decision. And I think that's why some people are angry about student debt cancellation as a potential tax burden. But there is an opt-out provision so that you can decide if you don't want the 10 or 20K forgiveness to not have to bear those tax consequences. I don't know if that answers your question. Yeah.
One of the challenges we face is we actually haven't seen the application, right? All of this is, the train is moving as we're trying to figure out where the tracks are pointed, to more push the analogy. Was there another?
It strikes me that the current situation is more than Byzantine in its complexity. And my probably silly question is, has the Department of Education ever contemplated putting out a comprehensive treatise that human beings could actually read on these are the different programs, these are the different rules, this is the how-to sheet? From your laughter, I see it was a silly question.
No, it's not a silly question. It's a great question.
It's a great idea.
Yeah. I mean, if you look at there's the department has a PSLF website, right, that attempts to walk the borrower through. One of the challenges is we have the current repayment plans and current direct loans, right, where the student is borrowing directly from the Department of Education. But then there are what Sophia referred to, the FEL loans. That's the old guaranteed loan programs. It hasn't been long enough that all those loans are paid off. So some borrowers have those loans, right, which are not held by the federal government. That's going to be another line of attack, another kind of litigation against the Biden cancellation plan. So there's some of the complexity is a result of building in layers, program on top of program. And there is not, at least yet, I mean, what there really ought to be is like a bot where I type in my information and it asks me questions, right? Like a TurboTax thing. Yeah. I wish. I mean, the National Consumer Law Center has a compendious, right, I don't know if it's a treatise, but on student loan law. It's more than even I think a law student could be expected to wade through. And so it's partly a resources out there for people to learn, but it's also simplifying the system so that it's not so the word you use, Byzantine, for a student borrower to navigate. Yeah, but it's hard to do when there are all these legacy systems and legacy loans that are still out there, right? That haven't been paid off.
If you're interested, the Department of Education does have extensive regulations and handbooks internal handbooks that are publicly available that do describe every single procedure you should need to take to process these applications, but they are long and dense and not a fun read. But they have also made efforts, well, I guess there's parallel tracks, one to teach their employees on training them to understand the different loans and then what to do once they receive an application, how to treat, for example, loans that have been consolidated versus loans that haven't been. And then there's public-facing materials that are more intended for the average consumer, average borrower, and the department has made some significant attempts at better outreach. And there's also, in addition to the public service loan forgiveness website, there's a specific website for disability-based discharges as well. And an increased trend toward online tools where you can fill it out online and then it'll auto-generate a form. But doesn't fix the overall issue of the piecemeal policies, legacy programs. I don't know if there's a magic wand that can fix all of that.
This is just a comment, but to explain how complicated these programs are, the loan servicing companies, those are the ones that manage the loans for the Department of Education, their staff don't even understand the program. So when borrowers call, it sort of depends on what person answers the phone, whether you're going to get a complete and knowledgeable response. And that's a huge part of this problem with student debt, is that borrowers are being misinformed by people that are supposed to be telling them whether they're eligible for PSLF, whether they need to consolidate or not. So it makes it even more complicated when the people who staff these call centers don't even understand the system. And then how are borrowers supposed to understand it if they're just the borrower?
As you all know, the rulemaking process takes a long time. You have to publish proposed regulations, you have a comment period. But of course, the administration is eager to announce changes and announce policies, but we have no idea what that means and what the regulations are actually going to look like. So the time that the news breaks and we get all the questions, we have the least amount of information. And then there's a long period, a long delay before we can get more clarity.
Yeah, and each of those potential missteps has consequences. So you can imagine a borrower who graduated from law school, say in 2011, 2012, with a mix of direct and guaranteed loans, who gets bad advice on whether to consolidate, which consolidation is taking all of your loans, bundling them together so you have one monthly payment to one, right, to one, through one servicer, right? And so if you consolidate after that, you would consolidate into the direct loan program. You wouldn't have any payments to the prior guaranteed lender. If you get bad information on that one step, right, then 10 years later, when you submit your application for public service loan forgiveness, you discover that actually you weren't on the correct repayment plan. And you can't go back in time and fix it, right? So that when I said at the outset, the complexity itself as a cost, it's both a systemic cost, but it's also a very individualized cost for the student borrower who might find that as a result of bad information received, they're now ineligible for relief that was intended to be available for them. It can be very frustrating, I think. Oh, yeah.
I may live in a fantasy world asking this question, but you're talking about debts incurred, and some of us went to the University of California or the state schools, when the state had a policy of investing in students who then went on to become taxpayers. And is there any talk about revisiting some of these decisions that have essentially made the universities and especially the law school a private institution?
Yes. I mean, there are lots of conversations. So New Mexico, I think just recently, they announced that they're eliminating tuition. So it's a state by state question, right? Which is a little bit worrisome for me if I'm thinking about, what's our national policy to subsidize higher education access? Is it really going to come down to a state by state political battle to see whether there's a will to permanently allocate the resources to provide that kind of access? Yeah, those conversations are certainly, right, certainly happening. But it's expensive, and the state share of support, as you noted, has not kept up with the growth in the size of the student population at the big public university systems. Yeah, it's a great question. I mean, one thing that I've said in the past is, I'm really supposed to be learning how to be a First Amendment scholar or something like that, because the student loan thing, really, we can just fix. This was just this, there's some really intractable problems, but this is just a dollars and cents one, right? This was just a mistake in how we chose to subsidize access. So let's just fix it and move on. But of course, it's not that simple at all to just fix it. Yeah.
Thank you. I'm not sure how germane my question might be, but I'm wondering if there's been outreach to high school students. And I say that because I remember several decades ago, there was controversy about teaching financial literacy in the public schools. Again, it's rearing its head, I think, in 2021 or whatever. I'm not teaching, and I'm retired for a while. Is there outreach to high school students? Is there any teaching of how debt works and maybe what programs might be available so that we're not addressing it later through litigation, but perhaps taking steps beforehand?
Not enough is the short answer. Not enough. And our organization has in the past proposed legislation to require financial literacy classes. It has not passed, but I do believe that we intend to continue to push for that because, as you said, very important. But again, doesn't solve this problem of the cost of higher education and the access, right? I'll also say that financial aid counselors who are helping students or potential students make financial decisions often present themselves as counselors, objective counselors, but really are biased and have a business incentive to enroll as many people as they can, and often they have quotas that they have to fill, number of loans they have to sign people up for. And so it is a very, very messed up system for a student to walk into.
One worry I have about focusing on, so this comes up in the context of advocacy for financial literacy, And one of the worries I have is suppose a student is very thoughtful, looks at the dollar amounts, looks at the implications of indebtedness and says, you know what, I'm not doing that. That's a policy fail, right? I mean, if the goal here is to try to put higher education within reach, then I'm worried if the system that I've set up to enable that is actually undermining the goal. That's why I worry about the implications. So I, on the one hand, yes, students absolutely need to understand what they're getting into. They need to make informed decisions. On the other hand, I'm naive. I want these young people who want to pursue higher education to be able to pursue it.
Systemic undercutting is incredibly important, and that's why I ask about the public trust, because you know, it seems that the legal profession made a choice to merge law and equity, and what the public trust is all about is the separation of legal and equitable ownership. And the thing is that it's a professional choice on the part of the legal profession, actually, of the merger of law and equity that created a lot of this confusion. And perhaps, you know, merged with the question of bankruptcy, the legal profession has gotten very adept at selling defenses where people win in bankruptcy. And how can the legal profession, which has a business interest in, say, Byzantine systems, how can they claim any credibility whatsoever in simplification for the broader society if they always have, well, you know, their fees are privileged in bankruptcy. And anyway, I think that's a big question.
Were you going to respond to that?
Not directly, but the question.
Okay, 1 second while the mic gets.
One of the things that came to my mind as this gentleman was speaking was, and related to some earlier comments, how do we, including yours, Professor Glater, yes, we want to encourage kids to go to, to pursue college education, but not at Heald College. Right. And there are these colleges where there has been outright fraud, and that seems like it ought to be an easy fix and a non-controversial fix, that those loans should be entirely forgiven. But there's a big range. I'm going to say going into debt to get a law degree from Berkeley is always going to be good debt. But not all student education debt is good, high quality, ultimately economically positive debt to go into. And is there any way to address that question? Is there any attempt to address that question?
Yeah. So yes, to the first part, the gainful employment rules that got press coverage a few years ago attempt to rein in the kind of bad conduct that you're talking about, right? Where eligibility to participate in federal student aid programs would depend in part on the ability of graduates of your program to repay their debt obligations, right? It's a fairly complicated structure that was set up to do this, and it's backward looking, meaning it's looking at repayment rates of the past to determine program eligibility in the future. So which means it's not the speediest. There are other steps you could take. Remember when I said at the outset that one of the striking features of the Higher Education Act was to direct money to the individual student and let the student choose where they want to go. Other countries don't pursue that model, right? You would say, look, this is the publicly subsidized institution, and the money is going to go to the institution, right, rather than to the student, and we're going to sacrifice student choice of program. We haven't done that, right? There's a wonderful book by David Lavery at Stanford, and he calls it's called A Perfect Mess, and that's his description of higher ed in the United States. Because there are so many different kinds of institutions and a spectrum of funding mechanisms, right, for ostensibly public, but that also get a lot of philanthropic support, and ostensibly private, but get a lot of federal support, right? So we could talk about that structure. There are a lot of vested interests in the structure that we have now, and that depends on that portability of aid and the primacy of student choice of institution to attend. Did you I'm seeing that we have 2 minutes left, so maybe one more, and then please.
I'll be very quick. Apologies if you touched on this and I just didn't absorb it, but how is public service defined for purposes of these public service programs? And are there careers and sectors that are maybe public interest careers, but are excluded from participating in these programs?
Yes. For public service loan forgiveness, basically there's a blanket coverage if you work at a 501c3 nonprofit or in government at any levels, local, state, federal, tribal. And if you work there full time, it doesn't matter what you do, it qualifies for PSLF. Then there are these sort of like non-501c3, not-for-profit organization categories of what they call public service. So it'd be like legal services, like fire and emergency responses, like things like that, childcare. There's a list of like 10 of them that they have laid out for whatever reason. And it is extremely hard to get a non-501c3 to qualify for PSLF, even though they've kind of listed this out. It's basically up to their discretion to decide if an organization meets that public service definition that they've laid out, if that's like their primary purpose or not. So really the safest bet is like 501c3 nonprofit or government. There are certainly things that are considered public service or public interest in my eyes that are not included, like working for a union or a 501, is it C6 a union, C4 is a advocacy, but like all of these things don't qualify. And there's been in their proposed regulations that they put out this summer to change public service loan forgiveness, they're kind of wondering, like, I think in California, some nurses are like not allowed to be employees of hospitals, and they work for like private companies, which doesn't qualify for PSLF at all. And so there's some consideration of like, well, maybe should we allow these people to qualify for PSLF or not? But it sort of brings up this interesting idea of, well, we have to look at what you do at your job, and like, are they gonna get into the business of like evaluating on a case-by-case basis whether something qualifies or not? But certainly it could be expanded, and that's a huge issue with people who are working at not-for-profits that don't fit into that C3 category. I don't know if you have any good thoughts.
Okay. Thank you so much for bringing all these questions. I had this list prepared, but I didn't have to use any of them. Ted gave me a couple. Of points that I'm supposed to make. First, it's now time for a lunch break. Please head toward the Alumni Lounge through the main hallway to your left as you exit the auditorium. There is plenty of outdoor and indoor seating available in Cafe Zeb, the West Courtyard, Steinhardt Courtyard, and Heyman Terrace. The Supreme Court update with Dean Chemerinsky will begin at 1:30 back here, same place. And thank you all for coming. It's really, really been wonderful to engage with you. Thank you.